Just when you think this courtroom is under control, one man completely snaps, and the judge, she stays calm like ice. What happens next will make you rethink how fast a courtroom can turn chaotic.
Very well trained, ma'am. All right. What's the claim in this case?
We're entering into a consent judgment here. I was talking to the defendants and we've come to the understanding and agreement that the outstanding rent retained possession right now is $475.01. Court cost of $214. Total outstanding balance is $689.01. However, the defendants have agreed to pay $1,000 on the 5th of November, and then the balance of their account arrears by November 24th, 25.
Is that all correct?
The assumption that I get a paycheck from the government.
Oh, good.
I did make that quite clear.
Yes, I recall this. I recall seeing you. I mean, I see people real, but now I have to get their faces.
Because they're not represented by counsel here today, that they do have 3 days upon which you enter this judgment that they could file a written motion to have it overturned if they find a valid legal reason as to why they should not be held to it.
Oh, I'm well aware, counsel. I'm well aware.
Yeah, I don't think that's the issue. The real issue is, are they going to give her money?
Well, you did discuss.
Got it. So the check doesn't arrive. That's an option. Is that, but you can't get there until. So that's actually the backup plan for our federal government being shut down and not paying the people that work for us and everybody so hard and just deciding to leave them out lurching. Oh, I'm sorry. Did I say that out loud? Okay. So do you have any other questions regarding that? All right. So what I will do is I will enter that judgment for possession by consent with the writ date as specified in there. And then wish you the best of luck and just hope it comes through. All right. You guys take care of each other, please. The first writ date is the 5th, I think, for the 1,000, and then it is extended out to later, the 24th. Court does call the case of Arbor Meadows versus Don't Hope. Have you read over this consent judgment? Okay, yes. On October 9th, you signed it. Do you have any questions regarding this? Everything. It's okay. So you don't have any questions regarding this? All right. And what I'm going to do is I'm going to enter this judgment. Ma'am, you do have 3 business days to think about this. If you think that there's some confusion or something you didn't understand, you can come to the court and file a motion or just a writing saying that you'd like a hearing. What's the day there?
The 24th.
Thank you. That's done.
This is one of the most emotional beats in the entire session. She came in with no hope on day 1, and now she's suddenly employed and fighting to stay housed. Moments like this show how fragile housing stability can be. Be honest, would you grant her another extension or stick to the landlord's objection?
What's this one? This is that. Okay, thank you. Harbor Meadows versus Charles Carter.
Good afternoon, Your Honor.
Good afternoon, sir. All right, where are we on this case?
12 months.
All right, is that correct, sir?
Yes.
And to abide by the community rules and regulations, correct?
Yes.
All right, do you have any questions regarding this?
No.
All right. And were your rights under your 3-day right of rescission explained to you, sir?
No.
All right, I will explain it in its brief form. This is a consent judgment. You're unrepresented by counsel. You have 3 business days to think about this. If you believe that there's some legal reason, some confusion, or some right you did not assert, you would have to file a motion with the court within that time frame. All right, it doesn't mean that I grant it, but you'd have to file a motion within the time frame.
Got you.
Got it? Okay, then I will grant the judgment to the plaintiff by consent as to defendant. You're Charles, correct?
Yes.
Okay, so by consent as to defendant one, by default, but along the same terms as to defendant two. All right, and I've signed that. Thank you, sir.
Thank you. Bye-bye.
Bye. Arbor Meadows versus Maryland Pagel.
This is for our Madam Your Honor, and we're moving for dismissal on them.
Case is dismissed on plaintiff's motion without prejudice. Court does call the case People versus Beal Beal Properties versus Teresa I. James.
Defendant, you can see.
And Terry I. James. Hello. Your name? Okay, and where are we on this case?
Managed to get a job, start again.
Okay.
I do a letter from the temp agency that shows the tentative offer of a job. And yesterday I was here and got fingerprinted, which is at a school.
Okay.
While I can't pay them now, I do.
So I see, how much is owing? I need a sticker.
It's around 3,000.
Whatever. How much?
14, leaves balance of $3,230.
And then how much is your monthly rent? 1,000. So we're gonna go up a certain amount. Have you been trying to work with the landlord at all to try to see if you can?
I contacted them just because this all happened within the last couple of days. So did you get my email?
I did. I saw that she did send me an email that she had finally gotten a job. I just hadn't been in the office for the past 2 days. I've been
Okay.
in person all over the state.
So I had actually asked her at Headwise if I should contact them first or should we should, and I will ask you that now.
So, Your Honor, I didn't get a chance to keep the for the case call.
We're seeing a pattern today. Tenants trying to juggle old balances, inconsistent payment plans, and new hardship agreements. The judge keeps giving extra time, but only if tenants stay in contact and show effort. This next adjournment fits right into that pattern.
I am not in a position to extend anything at this time. I do know that with this client, I can communicate with them and see if this is a high number.
It is, but Ms. I. James has been working through some things. She's been trying to get through this, and she quite frankly appeared here on the first day without any hope, and she's now here and things have started to look up for her. So I will just say this. Here's what I'm going to do, because I'm going to do what I want to do anyway. Sure.
So I am working, I should be able to reach out to Paul.
Right, exactly. I mean, there's a lot of other things that she may be able to do if they ever get any money. So what I'm going to do is, over plaintiff's objection, I'm going to give her one more adjournment to the 31st, allow you to talk to the landlord to see if something can be worked out from inside James. October 31st, 2025 time, 3 p.m. Okay? Have a great weekend. Yes, ma'am. Court does call the case Beal Properties versus Stacy Hines. Stacy Hines, not here. Case is dismissed on plaintiff's motion without prejudice. Court does call the case Beal Properties versus Ebony Reese. She's here. Dismissal. Okay. Hello, your name? No problem. All right. Where are we on this case? What's
The past difference retained is $2,511.44. Court cost of $175. Total outstanding balance is $2,686.44.
all right. Ma'am, how are you intending on getting this paid?
I had an agreement with the property manager that because this isn't like what I pay every month. This is like a past due balance from they weren't charging me rent. And so now I'm paying my monthly rent and I'm paying an additional $600 every month to take care of the balance for them not charging me rent at all. And so because I was in constant, well, we went to a couple of different property managers since then, but at the time I would call them, email them, let them know you guys aren't charging me rent. It's been months. I didn't get paid. And so this was what they came up with, but it's so high in our business. It's not doing good right now. And it's hard for me to pay what I pay monthly and the extra $600 to take care of this balance. And so
How many months have you been paying the extra 600?
I do believe that's when my client filed, because I do notice that the extra 600 hasn't been getting paid since September. So I think that they, well, actually, hold on.
So it was so the 600 became a burden wasn't being paid.
No. It's not that it wasn't paid. I told them that my business has been not doing good right now, and we made an agreement not to do the 600. I told them if they could work with me for 2 months of the summer, then I would pay 150 instead of 600.
This is one of the most emotional beats in the entire session. She came in with no hope on day one, and now she's suddenly employed and fighting to stay housed. Moments like this show how fragile housing stability can be. Be honest, would you grant her another extension or stick to the landlord's objection?
And then, that was being paid up until this court stuff, and I haven't paid until we came up with judgments to see what would go on and how much I was supposed to pay.
Gotcha.
So it just hasn't been paid since September.
So either the payment agreement that she's been working on has to be codified in some type of writing, or
Yeah, that's
something has to be done. It seems like she was paying on it, realized her business is where it is, negotiated a lower amount for a period of time, and now is just trying to figure out where she's going to head from here and do whatever. So here's what I'm going to do. I'm going to adjourn this out 1 week now, knowing that, and then you keep in contact with Miss Lacey and see what can be worked out to try to get this in some formalized way for you. Okay? October 31st, 2025, time 3 p.m. Beal Properties versus Cosine Welch Jr. Your name, sir? All right. And what are we doing?
I just $1,400 of the debt yesterday. Remains at 47618, which I can pay over the next 3 weeks.
47618. Hold on a second. What do you have as this balance?
So I have $1,830.18. You pay how much yesterday, sir?
Portsmouth.
1,400.
I got an email from Brittany Marshall.
That would bring him down to $430.18 plus $175 court cost. So its total is $605.18.
And when can you get that paid?
Nah, I need to pay 3 weeks. 'Cause I still have to pay rent for next month.
All right.
So this in 3 weeks.
No, not at all. I'll get paid on the 23rd of 1,300, but I'm trying to focus on getting this paid because I don't, you know what I mean? I know I might have on the 3rd, I might have the amount for that month's rent as well as what's back paid, but I have what's back paid all.
All right, here's what I'm going to do. I'm going to adjourn this to October 31st, 2025 at 3 p.m. See if you can work something out with your landlord regarding your payment plan. If not, I'm likely going to enter a judgment on that date that will extend your time out some to try to get this amount paid without clicking into November. All right? She's going to hand you a card. Give her a call. See if you can work it out.
I'll some assistance, because I got like a rental lease with them as well.
Pardon?
Is there somebody I get some legal assistance? What's my
Did you see the video that played?
yeah, some forms.
The forum?
Taking the camera, take pictures of the coach.
People do it all the time, regrettably. You got something? We'll get that to you, sir. Okay? See you next week. Call Miss Lacy, see if something can be worked out. 3 p.m. That's what?
That's not.
I never liked the holiday. All right. Woodview Commons versus Whitney Albright. All right. Case is dismissed on plaintiff's motion without prejudice. And let me recall this one. Court recalls the case of Arbor Meadows versus Katrina Robb. So she's still reading? All right. So here's what I'll do, Ms. Lacy. Let me call the rest of your cases. Augusta Woods versus Montgomery, Augusta Woods versus Sove, Beal Properties versus Bishop, Beal Properties versus Tilly, Westridge Mobile Home Park versus Alvarado Lopez. Those matters are dismissed on plaintiff's motion without prejudice so that we can try to keep on time with the 3 o'clock block. If she's not quite ready, she out there? She absconded? She did? She does. What'd you say to her, Lacey? I was being very nice to her. What'd you do? So did she take all your paperwork?
This is, Cornelius? No.
Rob. I don't know where, I told her to read it. Okay, here's what I'm going to do. I'm going to step off in recess so that the video can be played. You try to find your defendant. If you don't find her, then if you got a copy of the paperwork, I'll enter it by default since she's not here now. Okay, fair enough? All right. Court's going to stand in recess.